Why has mediation captured the imagination of lawyers and managers who face disputes? Dissatisfaction with traditional resolution routes is part of the answer. Litigation is costly, prolonged, and produces a win-lose decision. Arbitration also results in a win-lose decision and is final and binding. In contrast, mediation is a rapid, low-cost process. Parties, not a judge, decide the outcome. The process is without risk. If the parties cannot agree on a mutually satisfactory outcome, they can resort to court. As eyewitness to critical segments of a mediation, decide for yourself why mediation has proven so valuable in commercial disputes. The case we're about to see promised to be a litigator's field day with contract and fraud claims, international parties, and prolonged discovery. A South American distributor of office equipment sued a United States computer manufacturer for $10 million for wrongful termination of a distribution contract. After filing the case in a California court, the parties agreed to mediate. They're employing the Center for Public Resources Commercial Mediation Rules, and they've selected a CPR-neutral panelist as their mediator.
Good morning. I am Steve Goldberg, the mediator you selected, and you are?
Irene Morshower, Anderson Kill, Counsel for High Tech.
Steve, I'm Bob Walker, Senior Vice President for International Business Development at High Tech.
I'm Richard Chernick. I represent Prosando.
And I'm Edward Meissner from Buenos Aires, and I'm the president of Prosando.
Thank you very much. Before we begin, just a word about the mediation process. I am not an arbitrator. I am not a judge. I am not going to issue a decision in this matter. Rather, my role today is to help you to work out your own resolution for your own problem. The way we will proceed, we will start in this joint session. I will ask each side to present its perspective on this matter. I will encourage participation by the business people whose dispute it is. After the joint session, we will move into private session or caucus. In these private sessions, I will ask you to be open with me, to tell me anything that you think might help me resolve this matter. Even if you don't want it repeated to the other side, and be assured I will respect that confidentiality.
After discussing the parties' signed confidentiality agreements and statutory protections, the mediator asked Prosando for its perspective on the dispute. Mr. Chernick stated that Prosando is a German-Argentine joint venture specializing in sales of office equipment. In January 1990, Prosando entered into a 5-year contract for exclusive distribution of high-tech computers throughout South America.
The exclusive aspect of the contract was crucial. We spend a great deal of money at the beginning of the term developing the distributor network and expect to find our profits at the end of that term. We spent 2.5 years committing our resources and gearing up to perform this agreement when High Tech suddenly pulled the rug out from under us, terminating the entire contract on 30 days' notice in June of 1992. Under the express terms of the contract, High Tech had no right to terminate the agreement as it did. Not only did they terminate the contract, they interfered with our ability to perform the contract during the 2 years that we were establishing our distributor network. And if I can show you, I have a chart here. January of 1990 was the date of the contract. For 6 months following that date, we got no product. High Tech insisted that they wanted to renegotiate to give them the right to distribute along with us in our exclusive territory. It was not until June of 1990 that we were able to get our first product. And then, 6 months later, in January of 1991, we find that the product that we've been distributing has been canceled. A new product is being offered, but they won't give it to us under the contract. They claim that we're not entitled to distribute it. It took us 6 more months until June of 1991 to resolve that dispute. They finally gave us the right at that time to distribute the Century, which was a substitute product, and we only had 1 year until June of 1992 to develop our network before the termination occurred.
As a consequence of High Tech's actions, Prosando claims, first, that High Tech breached the contract by significantly interfering with Prosando's performance and by wrongfully terminating the contract. Second, that High-Tech defrauded Prosando by knowingly entering into an agreement to sell a product when High-Tech knew it was about to be canceled.
Prosando has suffered $10 million in damages, $3 million for compensatory damages for losses incurred in developing the exclusive distribution network, $6 million in lost profits, and $1 million for loss of business reputation arising from the breach of contract and fraud.
Thank you, Mr. Chernick. Ms. Warschauer, from the High-Tech perspective.
In January 1990, High-Tech entered into a distribution contract with Prosando. Prosando was appointed the sole distributor in South America for one line of High-Tech's products, the Futura A and B mini computers. Prosando completely failed to implement this contract. They failed to abide by the order terms in the contract, which required an immediate order for 100 units or $1 million. And they failed to negotiate annual minimum purchase orders for each calendar year. First of all, the initial order was only for 50 units, not the required 100. Total orders, in fact, after 2.5 years of this contract, were only for 88 units. No negotiation or even discussion of annual requirements was ever initiated by Prosando, and they couldn't meet the agreed upon payment terms. They owe us $126,000 now for equipment shipped. Prosando totally frustrated the basic goal of the contract, which was to establish distributorships throughout South America. They held themselves out as experienced distributors of complex business products. However, we later learned that they had to develop a computer staff. Today, over 2.5 years into the contract, they have only 4 distributors, and all of those are in Chile.
Ms. Warschauer pointed out her client's good faith in patiently awaiting reorders. High-Tech even provided the Century series when the contract expressly limited Prosando's distribution rights to the Futura series. Termination was required, she claimed, by Prosando's failure to enter reorders, pay for shipments, and most significantly, establish distributors. She then summarized her key contractual arguments.
An express term in the contract allows termination for failure to negotiate minimum purchase orders annually. We also rely on implied termination rights arising from the total frustration of this contract. We are astounded at this claim for lost profits, since the contract specifically excludes lost profits arising from termination. We're here to collect $126,000 and to terminate this relationship.
Thank you, Ms. Warschauer. Mr. Chernick, High-Tech tells me that they had an explicit contract right to terminate for failure to negotiate minimum annual purchase order requirements. I understood you to say that High-Tech had no basis for terminating the contract.
That's right.
Could you explain?
Yes.
Prosando's response: yes, the contract required yearly reorders, but the parties had agreed that such a requirement would apply only after Prosando completed a full year of selling High-Tech computers. Since that year had just been completed at the time of termination, Prosando did not breach the reorder requirements. What's more, High-Tech waived any reorder requirements by not raising the subject sooner. High-Tech's response: reorders were required 1 year from the date the contract was signed. Further, High-Tech's patience in waiting for Prosando to place orders did not constitute a waiver.
Mr. Meisner, what do you have to add?
Mr. Goldberg, let me explain why Prosando is so upset about this whole matter. We negotiated the initial contract in good faith for the Futura model. Then, all of a sudden, High-Tech comes out with this new machine called the Century. They must have known that they were developing a new machine. Mr. Walker knows that you don't develop a computer overnight. Then, to make matters worse, they interpret the contract so that we don't have the distribution rights for this new machine, the Century. We interpret this to mean that they wanted to dump these models in Latin America, that we were victims of a scheme to dump these models, and in fact, we think we were defrauded.
No, sir. If I hear one more assertion of fraud, we're going to be out of these proceedings. These are the people that have represented to us that they were a supplier of office equipment, that they had trained people in place, yet in 2.5 years, they've only got 4 distribution systems in place.
Okay.
I want you to get our $126,000 for us, and then we'll be through with this proceeding.
Okay, I understand that there is some emotion here. That's normal. This is a significant matter for both of you. I think that this is a good time for us to move into our private sessions.
The initial joint session has multiple goals. Attorneys try to impress the mediator and opposing executives with the strength of their legal claims. Business clients are invited to share perceptions of central facts and can express pent-up anger. The mediator controls the questioning, assesses reactions, and seeks settlement clues. By giving equal attention to both parties, the mediator demonstrates his impartiality and commitment to assist them. When the joint session is no longer productive, the mediator moves into private caucus. At the beginning of the first caucus with each party, the mediator typically reconfirms confidentiality protections. As we join Prosando, the mediator is seeking information to understand the case better.
Rich, what do I need to know to really understand this matter?
Well, I'd like to emphasize that we had a detailed written contract that had very specific termination provisions. The implied termination right that Hi-Tech claims is simply contrary to those provisions in the contract. In addition, Hi-Tech's conduct interfered with our ability to establish our distributorship network and disabled us from being able to perform the provisions contained in the contract.
Okay. I understand, I think, the legal issue. Ed, I'd like a better feel from you for the business background. What did you hope to get out of this deal?
Well, we thought we were entering into a partnership-type arrangement with Hi-Tech, whereby we would be working closely together to mutually develop the market for the machine called the Futura in Latin America. Quite frankly, we thought the machine was an excellent machine. The price was good, the quality was good, and it fit very well into our other business line. We were willing to make the initial investment, but of course it was important to us that there was potential for future profit.
Ed, why are you here today? What is your goal in this mediation?
Well, let me assure you that we're here to settle this matter. We're not in the business of litigation. But time is of the essence. If we cannot settle this promptly, we're going to have to turn it over to the lawyers and litigate to the hilt.
Well, why is time so important?
It's very simple. In reliance on the contract with Hi-Tech, we have a large capital commitment, which we're paying interest on. We develop a sales staff and a support staff. We're having trouble keeping these people together, and there's a limited amount of time we can keep this staff together.
Okay, so you would like to continue in computer sales?
Oh, absolutely.
In the caucus, the mediator often seeks to shift focus away from legal positions to the party's interests and business goals. Here, the mediator involves the client by asking a series of questions in a form that encourages the client to discuss his concerns. The responses provide a sense of the client's priorities and potential settlement routes.
Have you given any thought to reconstructing this deal with Hi-Tech so you can distribute Hi-Tech computers?
You know, we're concerned about that because Hi-Tech has been a very risky partner for us thus far.
Well, what will it take to settle this matter?
Well, we've asked for $10 million in the litigation, and that's our demand today.
Mediators often serve as agents of reality, as we'll see in the next segment. They ask parties to reconsider their claims in view of such objective criteria as contract terms, principles, or a court's likely reaction. By gentle, non-hostile questioning, the mediator encourages parties to consider potential weaknesses in their case, modify damage claims, and consider settlement possibilities.
Let's talk a moment about your lost profits claim, which I understand to be for $6 million. Ed, what sales projections are you using in calculating those figures?
Well, let me assure you we've made extensive projections, and we think they're accurate, perhaps conservative. We project sales of about 150 units per year. That will be our existing distributorship and some developed distributorships.
How many distributors does that assume to get to 150 units a year?
Well, we think it will result in our needing about 7 or 8 more distributorships.
Any progress in that respect?
Yes. I will tell you that we have pretty firm commitments for 7 to 8 additional distributors, but we don't want this information revealed to Hi-Tech for competitive reasons.
Okay. Now, this is a claim for lost profits. What Hi-Tech told me was that the contract bars claims for lost profits on termination. Now, how do you think the court's going to respond to that?
Well, high-tech has to prove a proper termination in order to be entitled to the limitation. And since they terminated improperly, we don't believe that the exclusion is going to apply at all.
Okay, but that is going beyond the express terms of the contract and implying the requirement that termination must be proper.
Yes.
What's the likelihood that a court's going to do that?
Well, there's always some risk in interpretation.
There is? Well, can you put a value on avoiding that risk and give me an offer that might get high-tech to move?
In response, Prosando reduced its demand to $9 million. We join high-tech in the midst of the next caucus. Ms. Warschauer has just restated her legal arguments.
I understand your legal argument. What I'd like a better feel for, Bob, from you is the business background. What did you hope to accomplish in entering into this deal originally?
Well, we saw at the time, and really we still see today, a significant market for our North American products into South America. And we thought Prosando would be a company that could help us penetrate that market. But obviously we were wrong on that score.
What are your present plans for penetrating the South American market?
Well, we're looking at other potential distributors. We have come to the conclusion that we're not going to be able to sell in that market without an on-site sales staff.
Tell me what you mean.
Well, you remember I told you about that 6-month hassle we had over whether we were going to have the right to distribute products in South America as well as Prosando? Well, I'm a little embarrassed, but that really turned out to be meaningless.
This absolutely has to remain confidential. It's embarrassing to us, and we just can't have Prosando know about it.
Okay, but you do need a South American distributors. Have you given any thought to restructuring your deal with Prosando so that it might work?
I've advised my client that his best interest lies in completely terminating any relationship with Prosando.
High-Tech's reluctance to consider future business dealings with Prosando caused the mediator to ask for High-Tech's settlement proposal. High-Tech offered $250,000. This amount would compensate Prosando for sales it lost when High-Tech gave only 30 days notice of termination instead of the 90 days required by the contract. Following the mediator's reality testing, High-Tech acknowledged some weakness from canceling the Futura A and raised its offer to $400,000.
High-Tech has offered $400,000 to resolve this.
You know, they really don't understand. It was their conduct which prevented us from achieving our sales during the first 2.5 years and deprived us of the last 2.5 years to achieve our real expected profits.
Well, you say it was their conduct. What about their claim that you always had Futura B to sell?
Well, wait a minute, let me answer that. Futura B was available, but High-Tech knew from the very beginning that we were not going to market Futura B. Because it had features that didn't fit our market, it was more expensive, and it was a machine that we just wouldn't be marketing in South America. We did want to market the Century model.
Okay, but there is some risk that a court might say that the decision not to sell Futura B was yours.
Acknowledging some risk on this score, Prosando further reduced its demand to $8 million.
Prosando has come down to $8 million.
This is getting us nowhere. They don't have a chance of recovering those damages. The contract specifically excludes lost profits, and even if a court were to give them something, it'd be limited to this additional 60 days of lost sales minus mitigation.
Very well, I understand your position.
Mediation often begins with the parties exchanging legal arguments, insisting they'll prevail in litigation, and making little progress toward settlement. At this point, the mediator may focus on the costs of litigation in the event parties don't settle. Those costs may encourage parties to put their legal arguments aside, at least temporarily, and search for a mutually acceptable resolution.
If you do go to court, what have you talked about in terms of the likely costs of litigation?
I understand from Mr. Chernick that if we do go to trial, there'll be about 8 months of discovery, probably a trial of about 3 weeks, and it's going to cost us, I assume, at least $500,000.
And how long before you get to trial?
2.5 years, perhaps 3.
And if you lost the trial, would you think about an appeal?
Yes, certainly. We haven't reached that decision yet.
And after you had done all that, could you guarantee to Ed that you'd win this case?
Of course not, but I do think our position is quite strong.
Well, the problem is that is exactly what High-Tech thinks. So if we're going to make any progress in this matter, what I'm going to have to ask you to do, and I will ask them the same thing, is to let's put aside the questions of right and wrong for a little bit and see if we can work on some kind of settlement that you could live with, that they could live with, and that probably would not involve them paying you $8 million. Now let's just try, okay?
All right, well, actually, we've been discussing this and mulling it over. As far as high-tech knows, we only have 4 distributors in Chile. In fact, we have 7 distributors in Argentina, which are pretty firm, and 2 real possibilities in Brazil. Now, I tell you this in confidence because we don't want high-tech to know this and pirate our distributors. In fact, we also don't want them to know that these are all the distributors we have lined up in South America. But if we can get a firm deal for the Century Series, an exclusive distributorship in Argentina and Brazil and Chile, I think we can make a deal. But we don't want this offer coming from us. We want the offer coming from you, and if it comes back, I assure you we'll agree to it.
Mediators can facilitate settlement by proposing options as their own when parties refuse to put a workable idea on the table for fear of appearing weak.
If we were to structure such a deal, what would that do to your demand for $8 million?
Well, I think we could probably reduce it. I think we could probably reduce it to $5 million.
Let's explore that a minute. If you resumed operation, you'd have the 4 distributors you had in Chile, plus 7 in Argentina.
7 or 8.
Okay, and a couple in Brazil. So we're talking, what, 11, 12, 13 distributorships. Now, I think you told me previously that selling 150 units a year would give you the profits you had anticipated. Is that right?
That's correct.
Okay. Now, if you had something in the area of 12 or 13 distributors, don't you think you could sell the 150 a year and make the lost profits that we were talking about?
Yeah, I see your logic. If we could get a deal like that, I would recommend to my client that we limit our damages to $3 million.
In meeting with high-tech, the mediator also began by focusing on the costs, delays, and uncertainties of litigation.
In light of all that, time, cost, etc., of court, I'd like to try out perhaps an idea with you that's a little bit different from anything we've talked about so far. Now, Bob, you said earlier that you were studying alternative distributorship possibilities in South America. What have you learned in that study?
Well, yes, we have made some studies. And what we've learned is that no single supplier of office equipment can penetrate the entire South American continent. In fact, our studies show more specifically that of the 2 promising suppliers, Calfo is very strong in Uruguay, in Venezuela, and Colombia. And then Ventura is strong in Brazil and Paraguay.
Okay. Well, that gives me an idea. You haven't found any distributor from the list you just gave me who is strong in Chile. Now, at least, Prosando is strong in Chile. What would you think of the possibility, just the idea, of a limited distribution agreement that would give Prosando, Chile, and maybe 1 or 2 other countries where you don't have someone as the framework for a resolution?
Well, Prosando would be our leading candidate in Chile, but they haven't demonstrated they can penetrate any markets outside of Chile. Do you have any information that's different?
Okay, at this moment, what I'd like to do is, if this is a possibility, let me talk to Prosando and see what they think about it.
Okay.
Okay?
The mediator told Prosando of high-tech's interest in a limited distribution concept. He decided, however, not to disclose high-tech's preference to limit the deal to Chile. Delighted, Prosando reaffirmed interest in Chile, Argentina, and Brazil. Prosando insisted, however, on having the right to distribute all high-tech computer models, both existing and newly developed.
Prosando is willing to settle on the basis of a limited area distribution deal and has proposed Chile, Argentina, and Brazil. What do you think?
No, not all 3. Brazil is definitely out of the question. Ventura is very strong there, and I'm going to want to go with them. Chile would be all right. It's probably Prosando's strength. Now, Argentina, I would still need some assurances that they're going to be able to penetrate that market.
Okay, but if they can come up with such assurances, they can have distributorships in Chile and Argentina, right?
Yes, I would agree.
Okay, now what about the money? Can you go up from 400,000 at least so that they will have the capital to make this distributorship deal work?
High-Tech refused to increase its offer and insisted that any deal include $1 million in orders by January 31st of each year.
I think we have the outlines of a deal. High-Tech will give you distributorships in Chile and Argentina under two conditions. First, if you can provide solid assurances of your ability to distribute in Argentina. What can I tell them, Ed?
You can tell them we have 7 firm distributors ready to join us in Argentina.
Okay. Second, you must commit to purchase $1 million worth of high-tech products each year by January 1st.
Oh, we can do that. But what about the money?
You're still at 400,000.
Well, then we really have an open issue because we want $3 million in actual damages.
Let me ask you this. In order to get a good and profitable deal to distribute high-tech products, which is what you want, how low can you go on damages?
I don't think we can answer that today. I think we need some time to think about it, and I think we're going to have to make some calculations.
Okay, that's fair. Let me suggest this. It's late. Could you have some time to talk and us pick up tomorrow?
Well, we'll need some time to talk. We can't do it in the morning. We can do it in the afternoon.
Okay, gentlemen. Tell me where you are on the money now.
Well, we reviewed our figures very, very carefully, and we think we can reduce our demand for actual damages to $1.25 million. But that's provided we can resume operations promptly.
Well, Prosando is okay on a distribution deal limited to Chile and Argentina. They have authorized me to tell you that they have 7 solid distributorships in Argentina. They will commit to $1 million in annual purchases, but they want the right to all new products and not just to modifications.
Well, that part sounds all right, and we would give them the new products if they can get sales moving again.
And they've accepted our $400,000?
No. They say that they need $1.25 million to cover actual losses that they can't mitigate.
No, no, absolutely not. We're not paying anything close to $1 million. We had the right to terminate that contract. Don't they understand they're going to be before a judge and jury in a state where we're a major employer?
We have a deal on everything but the money. On the money, they are still at $400,000.
That's outrageous. We've come down from $10 million to $1.25 million in good faith negotiations. It's time for them to move. Why won't they move?
Well, basically, they think they terminated properly and they shouldn't have to pay anything.
Steve, let me make a suggestion. We have carefully looked at this termination waiver issue, and under California law, we think we're correct. You're an expert on contracts. What would happen if you were to do your own assessment of this issue, provide it to them on a confidential basis, and tell them how you think a court would come out? We think that that would help to move them and to close the gap here.
Well, I would do that, Rich, but only under 2 conditions. First, they'd have to agree. Secondly, you understand it would be based upon my own independent research, and you'd have to accept that the chips will fall where they may.
Absolutely.
Giving a non-binding opinion on legal issues or a likely court outcome is not the norm in mediation practice. However, if the parties have confidence in the mediator's judgment or his expertise in the subject matter of the dispute, they may agree to such an opinion to break an impasse. Mediators are often reluctant to offer such opinions until more traditional mediation techniques have been fully employed.
Bob, have you given any further thought to increasing your offer?
No, Steve, honestly, I don't mean to be adamant about this, but we're at our limit.
Okay, let me make a suggestion then. What would you think of my giving you and Prosando, a non-binding opinion or prediction, if you will, of how a California court would be likely to rule on this contract termination and waiver issue? I would do it based on my independent research in the hope that it would cause somebody to rethink a little bit their position and maybe break this impasse. Bob, what do you think?
Well, sure, I'd like that. I mean, I've been trying to explain to Irene that we really got an advantage here, and we should make the best of it. She's a little bit cautious, and I'd really appreciate your opinion.
Irene?
It's fine with me as long as it's non-binding.
In private caucus, the mediator informed Prosando that his assessment favored them. Elated, Prosando was tempted to increase its money demand until the mediator pointed out that such a demand could jeopardize the emerging deal.
The facts of this case, particularly High-Tech's failure to object to Prosando's inaction on reorders, indicates to me that you are going to have a good deal of trouble defeating Prosando's waiver argument. And if you do lose on that issue, you're looking at up to $3 million in actual damages, plus some reasonable recoupment by Prosando of its investments. I suspect that after hearing this, you are going to want to consult, and you're probably going to want to talk, Bob, to some other people in your organization. Let me leave you alone for a bit, and then we'll get back together and talk some more.
Well, your opinion is certainly not what I'd expected, but Irene assures me that it's as good an evaluation as we're going to get in the case. So what I did, I took your opinion and I discussed it with our president. He'd like to get this matter behind us, and he's authorized me to go to $1.5 million. But I don't want to pay $1.5 million, so you can go back to them with $1 million.
Okay, let me see if I can get the deal done at $1 million. Well, in light of my evaluation, High-Tech has come up to $1 million. Is that enough to do the deal?
No, we're sticking at 1.25 million. That's a fair number.
Okay, I have another suggestion. Under the prior contract, High-Tech retained distribution rights in your territory. Now, what impact did that have on you, Ed?
Well, we don't know whether they have actually sold computers in our area, but it's definitely hurt us. Potential distributors always ask us if we have exclusive rights. They obviously don't want to devote time and money and effort if they're not going to get the sale, if somebody else is going to come in and get the sale. So they're leery about joining the group if we don't have exclusive rights. It's definitely hurt us on recruiting distributors.
Okay, if I could convince High-Tech to give up its distributorship rights in Chile and Argentina, could I get you to come down to $1 million?
Well, I'm reluctant to come down any more. But if you come back to us with a firm commitment that we have exclusive distributor rights in Argentina and Chile, then we'll accept $1 million.
Okay, let me try. Bob, let me explore something with you. Do I recall correctly that you told me that your retention of distribution rights had turned out to be just about worthless?
Yes, I did, Steve, but that was strictly in confidence.
Okay, but would you be willing to give up that right to get Prosando to come down from 1.25 million to 1 million and close the deal?
Yes, I would do the deal for $1 million, but you can't tell them why we gave up the distribution rights.
That's great. We've got a deal. Let's get into joint session and tie it down.
In a classic example of effective mediation technique, the mediator used information given to him in confidence to overcome the last barrier to settlement. High-Tech viewed its retained distribution rights as worthless. Prosando saw those rights as impediments to its business. Without revealing what he learned in confidence, the mediator forged a valuable trade-off for both parties based on differing values each party placed on those rights.
I want to thank each of you for your efforts today. Every one of you worked hard, were reasonable, and the result is that we have a deal. We've resolved this matter. I have jotted down the key elements of the deal. You've all looked at it. Let me just go over it briefly so we all hear it together. High-Tech will grant to Prosando exclusive distribution rights in Chile and Argentina on Century and all new models. Prosando will order $1 million in product by January 30th of each year. High-Tech will not retain distribution rights in Chile and Argentina. High-Tech will pay $1 million to Prosando.
Right.
Right? Okay, you've all looked at it. Let me just ask you to initial it before we leave.
As we've seen, this mediation succeeded in bringing about a mutually beneficial resolution instead of the win-lose outcome of litigation or arbitration. With skilled mediator assistance, the parties crafted an outcome based on business interests. Moreover, the mediation was faster and less expensive than litigation or arbitration. Low cost, high speed, confidentiality, and mutually satisfactory outcomes. These are the reasons that more and more businesses regard mediation as their first choice among dispute resolution processes.